Welcome to the final lecture of the African Law Seminar on Democracy and Good Governance in Africa. The lecture on the African Union's response to unconstitutional changes of government in Africa will be given by Judge Abdelkader Yusuf, the former president of the International Court of Justice and the founder of the African Institute of International Law. Judge Yusuf and I have been working together for almost 2 decades to promote international law education for the benefit of Africa. I note with deep appreciation that he is the only distinguished lecturer who has contributed wonderful lectures to all 4 seminars and contributed greatly to the success of this new initiative, the African Law Seminars, which started just earlier this year. I fully support the African Institute of International Law, which continues to make an important contribution to providing the African law training needed for the development of Africa and the achievement of the goals of the African Union. My dear friend, it is my pleasure to welcome you back and to give you the floor.
I thank you very much, Virginia, and I thank you again for organizing these seminars. They are extremely important for the legal education of young lawyers, practitioners, and government officials in Africa. And they pursue the same objectives that are also pursued by the African Institute of International Law. We have discussed about this many times, and I'm very happy that you have also associated your initiative and you are doing it in cooperation with the African Institute of International Law. So you have already had several lectures on governance and democracy in Africa, and including a seminar lecture by Judge Penkioko on the Charter on Good Governance and Democracy in Africa, the AU Charter on Good Governance and Democracy in Africa. So I will focus during the 30 minutes which you have put at my disposal on the unconstitutional changes of government in Africa, which have been addressed both by the Organization of African Unity and the African Union. And they have been addressed because they have really constituted a big issue, a big problem in African governance. You know, during the struggle for independence, for liberation, for the emancipation of the peoples of Africa, the Pan-African movement always emphasized that the people or a people should be governed with the consent or with their consent, their express consent. And the main reason why they insisted on that was because African countries were colonized without the consent of their people. They were occupied, they were exploited, they were oppressed, and their natural resources were taken away, and the people were never consulted on any of this. So the reason why the Pan-Africanist movement insisted on the necessity of the consent of the people for their governance, for their government, that such governance and government should be based on the consent of the people, was that the people should be allowed to choose the form of government they want to have in their country. And the reason why the African Union in comparison to other international institutions and even to general international law, which does not, general international law does not prevent an unconstitutional change of government. It does not condemn it. It does not reject it. It does not call it illegal. It is totally neutral to the manner in which government is changed in different countries of the world. And that is basically due to the fact that there is an old principle on which is a fundamental part of classical international law, which is that there should not be interference, or the principle of non-interference in the domestic affairs of states. Well, that principle is not as strong as it used to be, and I'm quite sure that you are all aware of the fact that because of the development of certain aspects of international law, particularly human rights law, criminal law, international criminal law, humanitarian law, that all these aspects of international law actually operate already within the domestic jurisdiction of states. And therefore, it is no longer true that there is an absolute principle of non-interference in the domestic affairs of states. Although that principle is still consecrated and codified in the Charter of the United Nations. The United Nations, in fact, the Charter of the United Nations proclaims that the United Nations shall not interfere or deal with matters which fall within the domestic jurisdiction of its member states. It refers to the domestic jurisdiction of its member states. And therefore, international law does not reject, does not condemn, does not in any way negate the possibility of an unconstitutional change of government in a state, in any given state. It leaves that to the constitution and to the internal legal order of that state. But the African Union decided to do otherwise. And that is part of what I call the public law of Africa. A public law which has been adopted, developed, elaborated by the Organization of African Unity and the African Union in order to legislate on certain values, basic values, which are shared by the peoples of Africa. And apparently, it's quite clear that with the adoption in 1919 of the first resolution of the Organization of African Unity, rejecting and declaring unacceptable unconstitutional changes of government in Africa, followed by the Lomé framework. Lomé is the capital of Togo. The Lomé framework on unconstitutional changes of government in Africa, that the position of the African Union and of African governments became very clear with respect to unconstitutional changes of government. And for me and for you, an unconstitutional change of government would be anything actually which goes against the established constitutional provisions of a state. And therefore, any action which would change the government in a manner which is not in conformity or consonant with the constitutional provisions of the state. But for the African Union, in its first proclamation of the illegality and unacceptability of unconstitutional changes of government, it gave the African Union, and before it, the Organization of African Unity, gave 4 categories of acts which were to be considered an unconstitutional change of government. Number 1, a military coup d'etat against a democratically elected government. That was the first one. And of course, was the one actually which triggered the reaction of the Organization of African Unity and of later of the African Union. Because as you know, coup d'etats are actually very frequent in many African states. They also used it to take place in Latin America in the 1960s, 1970s, 1980s even. But since then, they have gradually faded as far as Latin American countries are concerned. And therefore, they have remained in Africa, in some other parts of the world, particularly Asia and the Caribbean. In Asia, the latest coup d'etat, which overthrew a government, was in Myanmar. And that was a very rare and very exceptional coup d'etat. But Myanmar had, in any case, known coup d'etats in its history on several occasions. And then the second form of unconstitutional change of government, which was indicated by the African Union and the Organization of African Unity, was intervention by mercenaries to replace a democratically elected government. The reason is very simple. Why this was indicated, the replacement or the intervention by mercenaries, because in 2 instances in Africa, first in the Comoros and then in Equatorial Guinea, mercenaries were recruited by outside forces in order to overthrow the local government. In the case of Equatorial Guinea, they did not succeed. Unfortunately, in the case of Comoros, they did. And the Organization of African Unity did not like that foreign mercenaries should be recruited by individuals outside the country in order to change a democratically elected government. The third form of unconstitutional change of government, which the Lomé framework indicated, was the replacement of a democratically elected government by armed dissident groups and rebel movements. Armed dissident groups and rebel movements. This happens sometimes in African countries. It does not happen very often. And if you look around in Africa, actually, although armed groups occasionally overthrow an elected government, it is mostly the army of the state which actually overthrows constitutionally or democratically elected governments. And the last category, which was indicated in the Lomé framework, was the refusal of an incumbent government to relinquish power to the winning part after free, fair, and regular elections. This happens perhaps more often in African countries. But the reason why it was included at the time was because of what happened in the Côte d'Ivoire, where a government that was certified to have been elected democratically by the United Nations Observer Mission and other observer missions, including of the Organization of African Unity, could not assume power or take over power because the government that was already there did not accept to step down. So those were the four forms or four methods of unconstitutional change of government which were banned and condemned and considered or declared illegal by the Organization of African Unity and afterwards by the African Union under the Charter on Good Governance and Democracy in Africa, the AU Charter on Good Governance and Democracy in Africa. Although the AU Charter on Good Governance and Democracy in Africa went further, actually, and added a fifth method, which was any amendment or revision of the Constitution or legal instruments which is an infringement on the principles of democratic change of government. This is a little bit more complex and more complicated as a method because it is something to which many governments in Africa resort in order to stay in power. For example, you know how many heads of state, after having served for 2 terms of office and the Constitution, and realizing that the Constitution barred them from running for a 3rd term of office or a 4th term of office, resorted to a change of the Constitution. And of course, in such cases, they do that deliberately in order to make sure that the government would continue and that they themselves, as heads of state, would remain in power. And that's how, in Africa, as compared to other parts of the world, we have heads of state who have been in power for over 40 years, 30 years, 20-something years. And this is unheard of because it clearly indicates that the elections which are held by these heads of state are not free and fair elections. It's not possible for a head of state to be elected by his people at around 90% or 80% for a period of over 40 years, every 5 years or 6 years or 7 years. They might as well have a king instead of having a president or head of state, because in such a case, it would be much easier. Nobody would waste one's time going to the polls and just going about the motions of casting a vote for an election which is totally predetermined, the outcome of which is totally predetermined, and which is not, of course, based on the consent of the people. So there are two legal principles which are at play here, which the African Union and before it, the Organization of African Unity, have based themselves on. The first principle is the principle of the right of the people to determine the form of government or the form of political arrangement that they would have for their state. If you take the example of the coup d'etat, a coup d'etat does not consult the people. The military leaders who make a coup d'etat do not consult their people. They do not talk to their people. They do not care about their people. What they care about is to take over power and to exercise it. And of course, they say they do it in the name of the people and on behalf of the people and in the interest of the people. But if this was the case, they could have immediately organized an election or a referendum, and actually call it observers from outside the country and organize it in a fair and transparent manner, a referendum on whether the army should take over power or let the civilian government that was in power continue in power. If what they claim is true, but what they claim is definitely not true. And even those who promise to hold the elections 3 years later, 4 years later, 5 years later, they either do not hold such elections, or if they hold such elections, because they say normally that they will not participate in such elections, they hold elections which are meant to ensure that the military leader himself is elected as the head of state. And that is happening very often in African countries. So the unconstitutional change of government in Africa is a denial of the right of the people to choose and to determine their own government and to determine the form of political arrangement that they want to have in their own country. It's a denial of that right. This is the problem with the unconstitutional change of government. And if we take the second principle of law, on which the African Union also bases itself when it has banned the unconstitutional change of government, that principle is the principle of self-determination or internal self-determination. Because self-determination, the principle of self-determination or the right of people to self-determination has two aspects. One is external, which relates to decolonization and the liberation of the people and their emancipation from alien and foreign occupation and colonization. That is the external aspect of self-determination. But the internal aspect of self-determination is for the people to be governed on the basis of their consent, that the people have expressed the consent to have a certain form of government, and that this form of government is based on their will. So consent and will, those are the two decisive factors which determine the form of government that a people should have. So long as the will of the people is missing, and as long as the consent of the people is missing, then the self-determination or the right of the people to self-determination has been undermined and has not been realized. So, if this is the situation, what are the remedies? Because it's not enough to say that we ban unconstitutional changes of government. It's not enough to say that we condemn them and we declare them illegal. You have to have certain remedies which actually prevent such events or such unconstitutional changes taking place. And the African Union has come up with certain sanctions. They have decided that they would sanction and adopt sanctions against governments that came to power through unconstitutional means. And the most important of those sanctions is the suspension of the membership of that country in the African Union, and before that, in the Organization of African Unity. But as you must know, that has not actually prevented young military officers from taking power in many African countries. You are all aware of the latest occurrences of this type. It started in Mali, it went to Burkina Faso, it went to Guinea, and it went to Niger. And a week ago, it occurred in Guinea-Bissau. And of course, in Chad, it happened in an indirect way, because when the president passed away, his son, who was the head of the army, took over with the leadership of the army, with the consent of the leadership of the army, but not the consent of the people. So this phenomenon of the unconstitutional change of government in Africa continues actually, despite its condemnation, its declaration as being unacceptable, its declaration as being illegal by the African Union. And the African Union has no way of preventing it. The ECOWAS, the Economic Community of West African States, tried to go further than the African Union and to adopt real sanctions against such states, particularly against governments that have come to power through coup d'etats. And therefore, they imposed sanctions on Mali, on Burkina Faso, and on Niger. You know, a characteristic of these three states is that they are landlocked, and that therefore they depend on their neighbors, particularly Senegal, Cote d'Ivoire, Mauritania in the north, of course, and others, in order to import goods from the outside. And so these sanctions were extremely painful. But they were not painful for those who assumed power, who took over power. Absolutely not. The leaders of the coup d'etat, who became head of state, minister of defense, and who were running the country, had access to everything they desired and they wanted. and they had no absolutely, the sanctions had no effect on them and on their way of life. The sanctions were a punishment against the people of the country, especially the poorest sections of the people. And that is why it actually was unreasonable, in my view, for the ECOWAS to impose these sanctions in a overall way. They could have imposed targeted sanctions against the people who took over power unconstitutionally. But they imposed wide sanctions on the country as a whole. And then the three countries, or the three juntas who assumed power in Mali, Burkina Faso, and Niger, decided actually to react. And their reaction was, we don't need to belong to ECOWAS, and therefore we actually leave the ECOWAS community and create our own Sahel community of states. And that is what they have done. And of course, they tried to survive and to continue to struggle and to make efforts to develop their countries. But it is a very, very difficult situation, because it's not only the ECOWAS which sanctions them, they are also sanctioned from states outside the African continent, and therefore they do not receive the same type of support, foreign aid, foreign loans that they were used to in the past in order to help develop the economies of their countries and promote trade with other countries of the world. So this is the situation in which they find themselves, which is a very, very difficult situation. But despite that situation, the coup d'etats, or the illegal change, unconstitutional change of government, continues, as we have all seen last week in Guinea-Bissau. And the army has taken power in Guinea-Bissau, despite the difficulties actually experienced by other military leaders in West Africa. So the issue of the coup d'etat, the issue of the unconstitutional change of government is not yet over. And the African Union, despite the fact that it is the fairest international organization which actually lays down certain rules, norms, and principles governing the unconstitutional change of government, and despite the fact that it has also adopted sanctions against such unconstitutional changes of government, the problem has not yet found a solution. It is a problem which is still there, and for which the African Union will have to find a better remedy than declaring it illegal, or even declaring it a crime, because in a protocol which constitutes an amendment to the protocol of the African Court on Human and People's Rights, the African Union, in its summit in Malabo, Equatorial Guinea, decided to create a criminal chamber of the African Court of Justice and Human Rights, which has yet to come into force, and which has yet to be created. But this protocol says once the African court is created and a criminal chamber of that court is constituted, then those who carry out coup d'etats against a democratically elected government will be indicted for the crime of unconstitutional change of government and will be brought before such a criminal chamber of the African Court of Justice and Human Rights. That is something that may happen in the future, but of course, it does not, for the time being, reflect the reality of the law because the protocol has not yet entered into force. But even if the protocol were to enter into force tomorrow, it has a basic weakness because the protocol itself says that this cannot be done against the sitting heads of state and heads of government of the African Union. Now, how does one interpret that? Because when a young military officer makes a coup d'etat, he declares himself the head of state or head of government of his country, which is a member of the African Union. So if such a head of state or head of government cannot be brought before such a criminal chamber of the African court, or cannot be indicted by the prosecutor of that court, so what is really the use and the value of the entire exercise? I think that what they meant perhaps to say is that those heads of state and government who come to power through a coup d'etat or other methods, the other four methods which I described before, unconstitutional, other methods of unconstitutional change of government, they will be immediately suspended from the African Union, and therefore they would not be heads of state and government of the African Union. That is the only reasonable and logical explanation that I could give actually to that clause in the protocol, because otherwise the whole exercise fails. But this is a story that will continue because the remedies have not yet been found. And I think that personally that those remedies lie first of all in education, in educating the armies, the military personnel of African states in their duty, which is to defend the country from outside interference and outside invasionist aggressions, and also to defend the people of the country from such outside interference and outside aggression, and to help the people, not to oppress the people, and not to take over power without the consent of the people. So the first thing that should be done is, instead of educating the officers of the military of most African countries in foreign academies, war academies, or foreign military academies, where they are not taught about the political situation of their countries, it's extremely important that they should receive their education in the country, and they should be taught how to respect the will of their people. Because this is really what is at issue here, the will of the people. And if the army does not respect the will of its people, then the people should rise up against the army and topple it. Because as an American professor who studies this phenomena once observed it, he said that what attracts a military officer to power is not his force and the fact that he has the power to topple a government. What attracts him is the weakness of the government. And that is true in most African states. It is the state that needs to be consolidated in most African states. The institutions of the state are very weak, and therefore it is enough that a division of the army marches to the presidential palace, takes over the presidential palace, takes over the radio and television station, and then declares itself the government of the country. What kind of state institutions are those? They are non-existent, because if there were solid state institutions, they would not allow a bunch of military officers to take over power in the country. They would react, people would react, and those institutions would also react. Because one thing which is exceptional in Africa is that one of the first acts of a military coup d'etat or an unconstitutional change of government is the dissolution of parliament in that country and the suspension of the constitution. And the strange thing is that the people who were supposedly elected by their people actually yield to the dictates of a group of people who were elected by nobody. So the members of parliament, as soon as the military officers take power, they just disperse and disappear. Is that a state institution? And the judiciary. The judiciary is so weak that the head of the Supreme Court or the Chief Justice of the country is most often called actually to administer the oath of office of the leader of the coup. How can a Chief Justice of a country administer an oath of office to the leader of an illegal government, unconstitutional government? So it is the weakness of the state institutions in Africa which actually are the cause of these unconstitutional changes of government. And it is therefore these institutions that need to be strengthened, to be consolidated, and to be made more resistant to occasional assaults by military officers or other individuals or groups which try to take over power in the country. And I think I will stop here because Virginia asked me to speak for about 30 minutes and take questions for another 30 minutes. But I have just realized that I have been speaking for 48 minutes or at least 45 minutes. And so I will give the floor back to Virginia so that she can put to me whatever questions, or you can put to me through her whatever questions you may have on the remarks that I have just made on unconstitutional changes of government. And I thank you all. Thank you, Virginia, and back to you.
Thank you, Judge Yusuf, for that very informative, powerful, and timely lecture. Um, my mistake. I was actually giving you an hour for the lecture and a half an hour for Q&A, but instead we will give you an opportunity to have some wrap-up remarks. If I may ask you a question, the protocol that would add criminal jurisdiction to the court. This is a very interesting, a very important um, development. I understand the AU is pushing very hard to get this to enter into force. Hajir has talked about this essential weakness. I think you have suggested a very interesting way to address this weakness. If these so-called heads of state and government are suspended, when I read the charter, and I'm not an expert, to me it was implied that we were speaking not of de facto heads of state and government, but of de jure, those who have been elected in accordance with all of the wonderful legal framework of the African Union for valid democratic elections. Is there any hope that there could be such an interpretation in addition to the suspension strategy that you
Well,
mentioned?
I hope so. I really hope so because that is the only possible interpretation. Because if the heads of state and other state officials who are in power at that moment, which means those who have actually come to power through unconstitutional means and unconstitutional change of government, if the clause is interpreted that way, then the entire protocol fails and has no effect whatsoever. You have to remember that they left this vague deliberately because at the time that the protocol was adopted, the African states were complaining about the fact that the International Criminal Court was indicting only African heads of state and African individuals. And therefore, they felt that African heads of state should not be criminally indicted by any court. But they did not want to be very precise because the issue arises which heads of state? Because the leader of Mali is as much an African head of state as the leader of Cote d'Ivoire or the leader of Senegal. But unless you say that the leader, this does not include leaders who have come to power through unconstitutional change of government, it does not become clear. But I think that is the way it should be read. And I hope that the future court will actually have the wisdom, and the courage to interpret it that way.
As you know very well, this is a frequent device used in treaty negotiations. When they can't agree, they make it rather vague. But I believe there's also something in the Vienna Convention on the Law of Treaties about the fact that the treaty itself should be interpreted in accordance with the fundamental purpose of the treaty. One of the reasons I think that this is so important is the difficulties you pointed out in the national institutions dealing with these situations, especially when the military is in power. So I really hope that the Malabo Protocol will enter into force soon, and I hope that there will be very courageous judges. I think there are who are committed to making this work. So I'm going to be optimistic. So now turning
Yes,
to the
I
turning
fully
to
agree with you. I think it is better to be optimistic. And let's hope that actually our optimism will finally win and will actually guide the future interpretation of this clause.
And I think that the voices of Africans are growing louder and louder. They want to see change. I see this often in the seminars that we hold. And you mentioned the importance of education for the military leaders As Nelson Mandela said, and I begin every seminar with this quote, education is the most powerful weapon we can use to change the world.
Yeah,
So we will keep going.
yeah.
You have talked about the difficulty of the African Union dealing with these situations. There is a participant who would like to ask you, have there been any situations in which the African Union was able to take effective action with respect to an unconstitutional change of government in the history of Africa? Can you give us one good story, or do we have to wait and place our hopes for the future?
I, I think that we will have to wait because I cannot absolutely give you an example. It's unfortunate. It's unfortunate because these are some of the most divisive issues in the African Union. You know, many commentators say that the African Union sometimes functions as a club of heads of state who protect each other instead of protecting the rights of their people. And so there is this kind of solidarity also amongst them. And that is why, instead of, for example, adopting targeted sanctions against the individuals who take over power, the only thing the ECOWAS heads of state can manage to adopt as sanctions is sanctions against the entire country and the people of the country, which are totally ineffective and which actually target the wrong people. And so I think it is very difficult for 50 or 54 or 53 heads of state to come together and to say anyone amongst us, including coup leaders who behaves in such a way, should immediately be indicted or action should be taken against him or her, and then implementing such a pledge. It's very difficult for them. They may put it on paper, but implementing it is a totally different matter. And therefore, African public law and the norms and rules that have been laid down by the African Union, the main weakness of these rules and norms is the lack of implementation on the ground. And that lack of implementation is mostly due to the inaction of the organs of the African Union.
Ben Kyoko gave the first lecture in this seminar, as you know, and he talked about the decline of democracy in Africa. In many of these lectures, the lecturers refer to the elephant in the room, state sovereignty, the lack of political will. Ben said something very interesting. He said that the future of Africa now depends on the will of the African people, and that they are the hope, and that there has been a lack of leadership in many countries. You also mentioned targeted sanctions. Some of these very wealthy people who come to power have bank accounts outside of Africa. And this is another issue that has come up a couple of times this week. The fact that the African Union needs to have better monitoring of the finances going outside of Africa. And the lecture on corruption that was given by John Gabodi, he made an extraordinary statement. He said that if the African Union could find a way to stop the flow of the corrupt practices of money going out of Africa, there would be no need to have any money from foreign donors with all of the strings attached. This was a very powerful observation for me. So now, if the participants will forgive me, I will go back to their questions. This is an interesting and difficult question. This participant would like to know, in your view, is there such a thing as, we all know there's such a thing as a bad coup. Is there such a thing as a good coup?
military coup.
That is not
No.
specified.
Yeah, I personally don't think so. And the reason is very simple. For me, if a person or a group of people decide to impose their own will on the people of their country, they cannot be acting in accordance with the will of the people, because they have determined themselves that they will impose their own will on the people. And for me, that is actually almost tantamount to occupation, because you can have foreign forces occupying your country and telling your people they are doing it for your own good, because others were coming to take over your country and this kind of things. No, nobody should take over your country for your own good. Nobody should occupy you for your own good. And nobody should impose their will on your people because they have decided to do so. Absolutely not. I have seen some coup d'etats that were not necessarily, that did not actually destroy the institutions of the country, and that did not undermine too much the economy of the country. But that does not mean that they have been good for the people of the country. Absolutely not. Because the reason why actually most African states lack strong state institutions is because of coup d'etats. You see, countries which have never had coup d'etats, Senegal, Tanzania, Kenya, Mauritius, Botswana, you take it. Those countries are the countries that have the most effective state institutions in Africa. And the countries that have been through several coup d'etats are the countries that have the weakest state institutions in Africa, because the first thing that a military coup does is destroy, get rid of the state institutions in the country. And it takes quite a long time to restore those state institutions and the effectiveness of those state institutions. And so I am not aware, and I don't think that there is a coup d'etat that's good. They are all bad.
One of the speakers earlier this week agreed with you, because the people who come to power through a coup d'etat, particularly militarily, they always justify it. They never say, we're just doing this for our own power and greed. They say, we are doing this for you. And so it's very difficult. So it seems to me that the speakers this week have said that there needs to be a line drawn. No more coup d'etats. Not justifiable under any circumstances. Basically, a principle of jus cogens, because the fundamental principles of Pan-Africanism, the fundamental principles of the African Union, the fundamental principles of legitimate leadership all depend on the will of the people. So let me share with you the concluding observations that I wanted to make at the end of this session today. I would like to express my sincere gratitude to the distinguished lecturers from Cameroon, Cote d'Ivoire, Gambia, Kenya, Lesotho, Nigeria, Senegal, Somalia, South Africa, and Tunisia for their wonderful lectures, and to over 2,000 participants from all 55 African Union countries who participated in the 4 African law seminars conducted during its first year.